Alrighty. Wow. Who'd have thunk it? This is great. Allison, do you need a chair?
A chair?
Oh, no, that's another Allison, sorry. Allison. Allison with the I. Do you need a chair? Maybe
Back table over there? Okay, perfect.
Wow. Good morning. Great to see you folks here. This is wonderful. Sorry.
One thing, if I could ask.
And your email address. What I was wanting to do is find out. Sorry, I need to try to do this on the microphone. I just want to get a list of, or I need to know who was here last time as well as this time, just in case we need to send out stuff. I don't want to duplicate or just sign the paper. Make me happy. It's all good. I apologize if it's a little chilly in here for you. I have a thermostat that's different than most people. I am roasting, so I had to have the window, the doors open to cool it down. I also find it's a lot more fun doing a presentation when people aren't sleeping because of heat. So, and lucky for you, I'm not going to be doing much of a presentation today. We have some wonderful speakers. We have Emily Wood, and many of you might know Ginny Arnott Wood, former parishioners, and we have Al. They will be talking on the financial topics, and Allison Sweetlove, right there, will be speaking about legal issues. And online, James, do you see Mary Lynn online? Mary Lynn, are you there? Yep, perfect. Mary Lynn is from the Diocese of Toronto, and she'll be talking about planned giving. So the order of the presentations will be, we'll start with Ginny and Emily on financial planning, and then we'll go to Mary Lynn about planned giving, and then we'll end things off, as all good meetings end off with legal issues. Sorry, Allison. That's the last one I'll make. That's the comment I'll make. So one of the things I asked for was a new name for the seminar, because end of life was a little terminal, if you know what I mean. I kept telling Roshni, I really want to call it Nobody Gets Out of Here Alive. But she thought that might not be the most inviting. So I went with end of life, but I've been asking people, can you please give me some suggestions? So I got the final chapter. Waiting for God, or for those who like the theater, Waiting for Godot. Sorry. A place for everything and everything in its place is kind of a planning thing. Why are we not? That's not going ahead.
It will in a minute.
It will. It's waking up just like me. Okay. There we go. This time I'm getting things my way. That's more along the legal side of things. Stairway to Heaven, or others had a different approach. So thank you for your
Just came to the beginning of the end. I don't know.
the beginning of the end. Oh yeah, why not? The beginning of the end. So we've had lots of contributions. Thank you, Elizabeth. That's great. So the objective, very clearly, very quickly, I should say, because some weren't here for the first session. The objective of all of this, of the series, what's this rascal not doing? You'd think I know how to do this. Oh, someone's logging on. There we go. Okay. I showed this last time as well. During the pandemic, when people couldn't very easily attend, go to a funeral home, because remember, we weren't allowed, we had the social distance, you couldn't get together. It was almost one step away from people showing up and talking to me as the head of the cemetery board. They're like, here's grandma's ashes, can we bury them on Tuesday? So people didn't have a funeral home to step them through the process, because we don't do this a whole lot. So I started to realize people need a roadmap. And one of the things I found out, especially from the last session when we talked about how, the burial plot, we talked about your funeral service, and we talked about how to work with a funeral home. it was very instructive for a lot of people, even, and I'm gonna dive right in, so if you're uncomfortable, I apologize, but really from the point of death, when someone dies, what are the steps? How do things go? And who declares the death and all these kinds of things? Brian hadn't even thought about that because when people walk into Turner and Porter, they already know they're going to engage someone who can lead them on the route. But if you haven't done that, you don't know what comes first and what comes next, right? So that's one of the reasons we wanted to do this. And literally, I mean, people would show, as it says, and I thought self-checkout at Walmart was bad, where the sign that says self-cemetery. So the point is people needed guidance, and that's one of the key things of why we decided to have the seminar. The objective was to inform, inspire, motivate people to take action and put plans in place for the inevitable. As I've told Roshni many times, no one gets out of here alive. That's what we should call this. But anyway, so some don't plan because it's uncomfortable. And what we really wanted was an environment where people could have the conversation, they could learn, they could start taking action if they haven't already, in an environment that's comfortable and non-stressful and amongst friends. And that's why we decided to do this, and it seems to be working out okay. So that's great. And to bring in subject matter experts. So I'm not a subject matter expert on legal or financial planning or how to run a funeral home and how to work with them. I know how to bury you, so I got the last chapter done. But all the we have some experts here, so that's great. And this is the key thing is this is not a be all and end all. This is just to give you some insights to start the questioning, start the planning, and start taking action yourself if you haven't already. And this is also if you've already put all the stuff in place. If this is check mark, hey, I've got it all in place. That's fantastic. But a lot of people don't. So that's why the series. And just thinking. There we go. So the agenda is 3-part. We did the one seminar 2 weeks ago. Today is about legal and financial matters and plan giving. And then the third part in 2 weeks from now is more, I call it residential options and strategies, but it's downsizing, it's decluttering, it's all the stuff that you need household related in order to get your stuff in order. So that's going to be a different topic. Still working on getting some experts. And this is how many people were here to the first session by a show of hands. Okay, now keep your hands up. Everyone put your hands up. And now how many actually started working on a binder? So take your hand down if you've done, I'm trying to embarrass the people who take that. Just kidding. So you can put your hands down, it's okay. So the point is get that, whether you call it all you need to know binder, some call it, I said last time, the dead book, whatever you want to call it. But it's a book with all that information. So when you're gone, your family or friend or whoever knows where all the important stuff is. Yes.
I had one that passwords.
Yes, exactly. Well, that would be down in, it would be under the personal information. Yeah, but that's great. Passwords are key. And just remember, Facebook will never take you down. So just get over that. But the other stuff, you should have that all written down and in your binder. And in the binder, I also recommend if you have a safety deposit box, that's where the key goes. And then the family knows exactly where that binder is kept. So, when they need, they can get all that information. Oh, I went too fast. Okay, so with that, we're going to start going with Ginny or Emily. I'm not sure who's good. Ginny, you're good? Okay, great. So Jenny's a former parishioner of St. Peter's. Then you moved to Hamilton, I think 13 years ago, did you say?
It's actually we live in Niagara region.
Oh, okay.
Yeah, so we come a little further from there. And 13 years ago.
Nice.
So
Great. Well, thank you so much for being here. And here is, that should, if you talk to it nicely, advance.
All right.
And if you could be by the microphone so the folks online can hear this. So thank you.
Can you hear me? Doesn't sound to me like it's.
Just pretend you're a rapper and hold it up.
Yeah, I should just take it out of them. Be the rock star I was thought. Sound work? Okay, great. Okay. So thank you, Tom, and thank you all for coming, and it's really a pleasure to be back here again. I sort of feel in many ways like we never really left St. Peter's because we still see lots of you in one way or another over the years. Anyway, I sing in the cathedral choir in Hamilton, and some of you who still sing in the St. Peter's choir, we see each other sometimes when we're doing evensong. So anyway, we sort of feel, Emily and I, as if we really never left, which is fantastic. Anyway, I've been a financial advisor for almost 30 years. And certainly estate planning has become more and more an important component of the work that we do, because it's important if you've built a lifetime of saving and so forth, that when you pass on, you're probably not going to have used up everything that you had in terms of your financial assets and so forth. So we want to make sure that, however you would like it to be passed on to the next generation or whomever, that it's done in advance and that it's done properly so that everything happens the way you want. So first thing we will talk about, and I think you've already covered some of these things, and we will probably overlap with Allison's presentation as well. But estate planning considerations, of course, have to do with ensuring that you have a will and a power of attorney, that you have what we call an estate location finder, which sounds like it's the binder that you discussed doing before, and that you do things like assign beneficiaries to your assets in one way or another. And also that life insurance can sometimes be a helpful option for certain kinds of estate planning considerations. So will and power of attorney, we're just going to touch on this briefly because Allison will talk more about this, and we don't do these kinds of things, but we really advise people to make sure that they have them in place, that you have a will and that it's updated maybe at least you look at it every 2 to 3 years and update as need be. So that you make sure that your estate is going to be passed on the way you'd like it to be, that you name an executor, or it could be more than one person, but at least 1 or 2 people, or it could be a trust company. It doesn't have to be an individual. And they do things like they file for probate, which is goes to the government. They ensure that your personal property and your financial assets are distributed according to your will, and they do things like arrange for and pay your funeral and final expenses and that sort of thing. Power of attorney is important because that is somebody who can speak for you if you're incapable while you're still alive. Super important because we all hope we will never need that, but it's important to have it just in case. And just bear in mind that a power of attorney ceases to exist when you pass away. It is only about speaking for you while you're alive. The estate location finder, we have some little booklets that we give to people to help them make sure that, as we discussed before, that people know where to find the important information. And it's something that you need to update periodically too. Location of your financial assets, bank accounts, investment accounts, and account numbers, and all that important stuff. And needless to say, you're going to want to put this in a safe place because you don't want that, getting into the wrong hands necessarily. But it's really important that it be available, and maybe you give it a copy of it to your executor. That's a good idea, or certainly make people know where they can put their hands on that. The location of personal property that matters, jewelry, stamp collection, anything like that. Your digital footprint, as I think you discussed before, email, computer codes, Facebook, LinkedIn, Instagram, all those kinds of things. And any ongoing subscriptions. Do you have a Globe and Mail subscription online or otherwise? All those kinds of things that probably need to be discontinued. And other instructions, funeral arrangements, and even things like informal gifts to people. Maybe it's not something that's going to appear in your will, but maybe there's an important piece of memorabilia that a family member would like, and you want to make sure it goes to the person who want it to go to. So that would be the kinds of things that you would record in an estate location finder. One thing that we get asked a lot about is, making sure that beneficiaries are assigned to assets that where that's possible, and it's not something you can do with everything that you own. So things like RSPs, RIFs, TFSAs, first home savings accounts, those all allow you to name a beneficiary or beneficiaries when you open them. But other kinds of assets, things like bank accounts, the value of your home, cottage, business, all those kinds of things, those are governed by your will. So that's why a will is really important, so that you can determine, you can specify who those assets will go to when you pass. The same with insurance policies. You can name an individual, recipient, or a corporation or a charity. And joint accounts, those especially that have right of survivorship, would mean that those assets would automatically transfer to the other owner upon your death. Some just quick life insurance options, things like term insurance, which are going to have a specified 10-year, 20-year term, and then they end after that. At that point, they can sometimes be renewed at that stage, but inevitably it's going to cost a lot more if you renew at the end. You're 20 years older than you were when you took it out. Term insurance tends to be the least expensive form of insurance that you can take out. Universal life, they call it, or term 100. It never expires. You continue to pay throughout your lifetime, but the premium it never changes. Once you take it out, it remains the same, and it's guaranteed to pay out because it basically goes until you're 100 years old. And it's considered permanent insurance. Whole life insurance is similar to permanent insurance, but it is permanent insurance, but it often incorporates a sort of a savings and investment component to it. So it's a little bit more robust, maybe we would say, than strictly universal life or term. Annuities are another form of insurance, but it's something that you would generally, it's something that can be used to create income either for yourself while you're alive, or you can designate a certain amount of money be put into an annuity for an individual upon your death, so that they will have some kind of ongoing income. So with regard to planned giving, why would you want to do that? Why would you want to plan in advance to put together a fund or something along those lines? Well, maybe you want to leave a legacy, something that's important to you, that matters to you today. You want to put money in a fund, and it can happen while you're alive. Of course, it doesn't have to just happen upon your death. You can start something while you're still alive to support charities and causes that you care about, and they can have also potential tax advantages to your estate, and also if you start a donor advised fund or something like that while you're alive, there are also some tax advantages to it. And what kinds of things can you donate? Well, they can include cash, of course, just outright. It can include securities like stocks, bonds, mutual funds, exchange traded funds, really any sort of asset that you have. It can also include real estate, a primary residence cottage, rental properties. Those can be donated to a charity. Life insurance policies, you can name a charity as a beneficiary or donate a policy to St. Peter's or to a charity. And how do you go about these things? Well, you can obviously make a direct contribution in your will. You say, I want a percentage of my estate to go to a particular charity as a one-time gift. Or you can establish an annual disbursement fund, which is to say you create a fund in your will that is going to then be invested, and the proceeds of that each year will be donated to a charity or charities of your choice. You can, if you've got enough money, you could create your own formal foundation, but you have to have, $10 million or more to really make that worthwhile. Could happen. Or you can create what they call a donor advised fund via your investment firm. Most of the banks and investment firms will have ways that you can set up a donor advised fund with generally much less capital to start with. It can be, I think, anywhere as little as $25,000, something like that. And you can add to it while you're still alive, and or you can create a foundation this way through in your will. Or you can create a donor advised fund via, say, a community foundation. I used to sit on the investment board with the Community Foundation of Mississauga, so I saw firsthand how it works when people make a bequest to a community foundation, and how those proceeds can be used for the benefit of causes within your community that you care about. One of the things that came up about putting together a foundation, either through a community foundation or some sort of donor advised fund. I think I actually had this conversation with Jennifer many years ago when I was working with the Mississauga Foundation, and she said that it's really helpful to a charity like St. Peter's or any other if there is a fund that is designated to give you a donation each year, and that that's something you can count on through one of these sorts of foundations. She said it's very helpful because it's money that they can plan for, as opposed to, as lovely as it is getting a one-time bequest, it's often something that comes as a surprise, a happy surprise, but it's not something that they can count on a regular basis. So as much as it's never discouraged, at the same time, the income that is possible through a regular donation on an annual basis is also really helpful. Oh. Trigger thing. Some tax advantages of charitable donations. If you donate a lump sum in cash for the estate, from your estate, the charity receives 100% of that donation as a charitable tax receipt. So that comes right off the taxes of the estate itself, which leaves more for the beneficiaries. You can donate securities in kind, and this is really an important thing. This is also possible while you're alive too, and I think a lot of people don't appreciate what an advantage this is. If you have stock in your portfolio, and this is outside of an RSP or a RIF, it has to be in a taxable account, where you've got Apple shares that have appreciated, they're double what they were when you bought them. Let's say you want to donate $10,000 and you have $10,000 worth of Apple shares that cost you $5,000 to buy. If you just cashed out those shares, you would pay tax on half of that capital gain. So if you're in the top tax bracket, it's approximately 50% of the gain. So that would mean roughly $250 dollars of the, or sorry, $2,500 of the $5,000 gain, and subtract that. So at the end of the day, you're really only able to donate $7,500, and you get the tax receipt for that, and that's great. But meanwhile, you're paying the tax on the capital gains. If you just donate the shares, the $10,000 worth of Apple shares directly to the charity, you get $10,000 in a tax receipt from the charity. The charity does not pay tax on the capital gain. They just cash it out. They get $10,000 to do with as they want. And, you get 100% tax, or tax benefit for the charitable receipt. So this is something you can do while you're alive. You don't just have to do it, in your will or in your estate. So I think it's a really great way to make, if you're charitably minded and you have appreciated stocks or bonds or mutual funds or anything in your portfolio that you'd like to donate it in kind, as opposed to selling the shares first. Real estate you can also receive a charitable tax receipt for donated property. My tax department advised, when I asked the question about this, was there anything that had to be sort of considered about that? And they said the only thing that's really tricky is sometimes you have to determine what the original value of the property was. That has to be, not only do you have to determine the property at the time that it's being donated, but also you have to be able to know what it cost in the beginning. That all has to be established when you make the donation. But the same thing applies. I mean, when it's determined, whatever the value is, by and large, it can be 100% tax deduction effectively for the estate. Life insurance, you can name a charity as a beneficiary of a life insurance policy. So they're going to get, all of the proceeds when you pass away. It's tax-free to the charity. Or you can also name a charity while you're alive. You can donate the policy to the charity. So if you were donating a policy to St. Peter's, they would be the beneficiaries. But if you continue to pay the premiums on that, then the premiums can be a tax deduction in your lifetime. So there are some really interesting things that can be done with life insurance policies in terms of donating to a charity. And that, in a nutshell, is what we wanted to bring to your attention. Anybody have any questions? Yes.
Does your beneficiary of a insurance policy pay tax on that, on the benefits?
No. So the question is, if a person is named as a beneficiary who receives the benefits from a life insurance policy, do they pay tax on what they receive? And the answer is no. No. Life insurance policies, or the proceeds to a beneficiary, are always tax-free. And that's because when you buy it, if you're the person that buys the policy, you're buying it with after-tax dollars. You don't get a tax deduction when you buy the policy, so therefore proceeds are tax-free when they go to the beneficiary. Any other questions?
I've heard of having a power of attorney for health. Power of attorney.
Yes.
That in the state. You have a power of attorney that can look after any decisions that be made by the health.
Yes. So, and I'm sure that Allison will speak more to this, but that's right. When you have a power of attorney done, you would have one for property, they call it, and one for personal care. And it can be the same person or people, but it doesn't have to be. It can be two separate people, depending on, who's got the acumen to do so. A lot of institutions can provide that, can provide like a corporate power of attorney, but just for the financial services, they can't provide that for personal care. So in that instance, you need to have someone or people who could be named for that purpose. Yeah. Anybody else?
Can everyone hear, okay? In here? Thank you. You'll notice there, for the three speakers we have today, there's overlap. So Jenny's talked mostly about financial, but talks a little bit about wills, and also talks about planned giving. Our next speaker will be Mary Lynn from the Diocese of Mary Lynn Stewart from the Diocese of Toronto. And she is the executive director of the foundation. I can't remember the proper name of it. We'll get to that.
Don't worry about
and
it.
she's
That's
going to talk
okay.
mostly about planned giving, but there's a little overlap. And then Allison, there's an overlap on estate. So there's nothing like repeating a good message to make sure that it, and each of them is coming at it from a slightly different angle. So Jenny, thank you very much. I have a question for you. Let me see. So that's actually, so thinking of the, sorry, I'm just, is it fair to say that it's probably a good, and this may be an Allison question too, I'm not sure, but is it, sometimes people try and do things to minimize the amount of money that has to go through probate, because probate is at 1.5% or?
In Ontario.
Yeah. Okay, so I've heard people try and do what they can to minimize the assets that would go through probate, because why give anything to the government? You don't have to. Is that fair?
Right. So
Yeah,
I,
we should talk about that.
I was gonna say, I'm sure that Allison will talk about that, but I run into this all the time with clients who are doing just that. Just, I heard that, we don't want anything to go through to probate. It's like this big nasty P word, which, is just sometimes so misguided, because there can be all kinds of negative repercussions if you try to put things in place the wrong way just to avoid that. And I'm sure you'll get into this more, but I mean, what I tell clients is that probate effectively is a fee that gets paid to the province to take over the responsibility of making sure that your estate passes the way you intend it. That's why they have to verify the will and the executors and all that sort of thing. Because no financial institution, especially if there are any more than $50,000 involved, is going to risk, just willy-nilly going with whoever says they're the executor, to disperse a big estate with the worry that maybe somebody is going to come out of the woodwork 2 or 3 years later and say, I am the child of so-and-so, and, they owe me lots of money that I was entitled to, blah, blah, and there was another will and so forth. So in some respects, it would have to go to court, and the province would have to be involved with actually dealing with that, as opposed to the executor or the institutions like the bank and the investment company. So that's really what probate is for. And when you sort of put it in that perspective, then people understand a little bit better that it's not the big bad just tax grab that everybody assumes it is. It actually has a really important function, and it's the only way that institutions will actually deal with dispersing an estate. It has to be done if it's of any size. And I would just say one other thing, just while I'm thinking about it, that in terms of the whole importance of making a will, I also see on my side the effects of what happens when people die without a will. It is time consuming, expensive often, and it is the last thing you want to do to your, the people that you care about in your life, that they'll just sort it out, or that, the kids will all figure it out. You know, it's the worst thing you can do to people. I just think it's an awful way to leave your affairs because it really, on top of grieving, it's difficult for them to have to contend with the fact that they now have to go to court to actually be able to, you know, move what's left of your life. And it's just not something that you want to do to the people you care about.
I have a question. You mentioned about a beneficiary, but you didn't mention succession holder. Is there a
Oh.
difference?
Yeah, on certain kinds of registered accounts, they call it a succession holder. I don't even know the legal reasons why they differentiate, but generally a succession holder for like a RIF account or a tax-free savings account is usually the spouse. It is not generally, you know, your children or anything else. And I honestly, I don't know why they make that distinction because it effectively is the same thing.
Okay, it's my understanding that the succession holder can get everything in kind, but if you're the beneficiary, it gets sold.
Oh, no, I mean, that's not a given, no. No, if there's an RSP or say a RIF account and the person has designated their two children to receive the proceeds, then a death certificate would be provided and a letter of direction. And if one of the two children would like to have just their half of that account passed over in securities that are already in the account, then they just have to tell us that's what they want, and you know, that's how it goes. So that's not an automatic thing.
Great question, thanks.
Yeah.
Does everybody have to go through probate, no matter how small or how big the
No,
estate is?
no.
So I thought it was like over 250,000 that you had to do probate.
No, it's,
Probate isn't based on value, it's based on the type of assets you hold. And so as Jenny mentioned, registered financial institutions have internal policies that say that to protect themselves from lawsuits and potential claims that they've dispersed money improperly, they require probate before they'll release the asset, right? So that's registered financial institutions. The land registry office has a similar requirement before they'll register a transfer of title to property. So it's really based on the asset as opposed to the value that we're talking about. So there's no threshold amount that says once you're over this, you need probate, or once you're under this, you don't. Okay.
So are there special forms that you fill out for probate?
Yes.
And it goes in with your income tax?
I'll
Not
talk
that
about
far.
probate when my turn comes.
Yeah, okay,
I
good.
know.
Yeah, what we just, for those online who may not have heard the chat in the room, there's discussion about probate. Allison will cover that when she gets to her talk, okay? So you won't be left out, those folks online. Any other questions for Ginny at this point? Oh, yes, Sue.
Just about RRSPs and RIFs and stuff. Because I'm over 71, so it's all getting turned into a RIF, I think.
At 71,
Right.
yes.
Okay, so when I die, I don't have a spouse, I have 4 kids, and I'm leaving it to my 4. And evenly, but they will have to collapse those RSPs and RIFs, right? And pay the appropriate amount of tax on them.
So for the folks online, the question is, what happens when you die? If you are the only remaining, you don't have a spouse, it's just you have registered investments. How do those get treated upon your death? Here's Jenny.
thanks. That's a really great question. So what happens is the say 4 beneficiaries receive the proceeds of the RIF. Now, because there's not a spouse, the proceeds can't roll over without tax. The tricky thing is that as a financial institution, we are not required, in fact, we don't have a mechanism to withhold the tax on the RIF before we disperse the funds. However, the estate is responsible for paying the tax on that account. So the 4 beneficiaries get to, carry on with their quarter of the proceeds effectively before tax. But and if they're not involved in settling the estate and so forth, the executor is going to be responsible for making sure that the tax money is available, that it will be owing on the dispersal of that account. So if that's the only asset that is being passed on and there's not a house that's going to be sold or other securities that will pay the taxes, it's tricky. I mean, the executor, well, a RIF account or an RSP doesn't even form a part of your estate effectively because it isn't governed by your will because of the named beneficiaries. So, but where's the tax going to get paid? And this is one of the tricky things that, there needs to be money available to pay the tax man, or you have to make sure that those 4 beneficiaries realize that they're going to be on the hook for paying some tax because of the estate needing to pay the tax. I mean, it can be very tricky if there's no other assets, but it will be taxable. The estate will pay the tax. The beneficiaries theoretically don't pay the tax. That can be a tricky situation if there's no other assets to pay the taxes.
Thanks very much. If I could ask, just write down any questions you have, because we have to skip to our next speaker. I wasn't paying attention to the time, and Mary Lynn does have a time constraint. So Mary Lynn, can you unmute yourself and say hello?
I'm unmuted. I'm good. Can everybody hear me? Okay, well, while we're getting the screen set up, thank you very much for inviting me today. As Tom said, I work for the Anglican Diocese Toronto Foundation, and we are one of those foundations that can actually help you with your estate planning if you're interested in including that your parish or any of the ministries within the diocese. My presentation will be smaller because I know you've just heard a wonderful presentation, but I want to give you an example of 2 stories of people that one left a will and one you never judge a cover. My brother, who was a lawyer at Denton's, a senior guy, corner office, died 8 years ago without a will. And my sister-in-law is finally sorting it out now. So that's just to back up what our previous speaker said. Wills are good to have. And, he was a lawyer and didn't have a will. So there you go. And I think he didn't think he was going to pass as soon as he did, but he did. So I share that story honestly. He might be embarrassed that I'm sharing that story, but he's not here. He's maybe listening in from heaven. But, he is the stereotype of 61 years old. I'm not going to pass for a long time. I'm whatever. And he had a heart attack. So you'd never, ever know, right? All the things we were saying earlier. Another example is when I worked for the American Cancer Society. Because there's always this image of, back to forming your own DAF, is that you have to have, you live in Rosedale, you whatever. But and it was a great thing to have as a very young fundraiser. We were left an oil well that was worth $1 million. But let me tell you, when I went to thank the family, if you went onto this farm, you would not have thought there was $1 million oil well waiting. So every little bit is wonderful to give to whatever charity of choice, your church, etc. So I do encourage that. So we'll move to the next slide. And some of these, sorry, Helen, you had a question? No? Okay. If we can move to the next slide, please. And I wanted to say, so in my personal life, I go to Church of the Resurrection in East York, and I'm a warden. And we are just going through the process of our pastor has just resigned, going to another church. And so we are going through the parish selection committee process. I don't know if anybody's, gone through that. So just some interesting stats. We'll let them pop up there for a minute from the wonderful Canadian Association of Gift Planners. And all of my fellow speakers will know this stuff too, but there's a lot of money that's going to be changing hands, right? Really, in the next 2 decades, 3.5 million Canadians are expected to pass away. I'm an aging baby boomer, so don't want to go there too far. Up to 1.5 billion is available for transfer. And then this is the one that we've been talking about. Only 30% of Canadians have an up-to-date will. And then here's one that goes up and down, and maybe I should even update this figure a little bit. Only 7% of Canadians support charitable organizations through estate gifts. Sorry, got a little bit of a dry throat today, so if you excuse me as my voice goes in and out. So we can go to the next slide. Oh, our favorite people, the CRA. So in 2021, 19% of taxpayers claimed donations on tax returns, which was down a third from the 1990s. That's pretty wild. Faith organizations are the largest beneficiaries. Hospitals and universities receive most legacy gifts, and less than 5% of gifts left in wills are to faith-based charities. So, and we know this as a lot of church populations have been dwindling. But I was going to tell you a really interesting thing from the diocese that my colleague Peter Mashazik, if he was here today, would share, is that overall church attendance is going up. I don't know, our church is going through that. So that's kind of a neat thing. So we can move to the next slide. Thank you very much for helping with the slides. Some of the things we've already talked about: bequests, outright gifts of cash, gift of securities, and life insurance. And we can go to the next one. And I was going to say, Tom knows the diocese actually, and I can mail it to people if you let Tom know if you would receive it. Tom, the box didn't show up, did it?
No,
Of the wills planning guides, but we also, everybody's got, but we actually have a 48-page booklet that when I first saw it at Synod, I was like, oh my gosh, who's going to take this? It was the hot pancake or hot whatever pancakes at Synod, and it actually, all the things we've talked about, it's a thing you can store your documents in, and all your banking, except the other things we've talked about. Best reasons to give transforms people's lives. You leave a memory, an act of kindness, contribute to the future, and to encourage others to follow your good example. Like I see that I had my children late, so I really have tried to live an example of, showing them how to charitable gifts. But let me tell you, as much as I've done planned giving most of my professional life for charities, I realized I hadn't updated my will. So I started doing these events with the bishop. I'm not married, and you better speak what you're doing. But these are some examples of bequests that turned out to be really wonderful. So Bishop John Strawn, we all may know that name or may not, but he left 250 pounds way, way back. And from that, we've been able to support the office of the bishop. Like it's that small, would have been significant at the time. But back to my earlier point, every gift is significant. The largest bequest that the diocese has ever received was $8 million. And then we also had the Betty Graham request as another example. We can go to the next slide. Excuse my froggy voice, it is definitely there. Some of the things we just talked about: deferred gifts has a favorable impact on donors' final tax return. Must be the direction the gift, and I know we'll be talking more about that after I'm gone. It simply represents about 75% of all planned gifts are the deferred gifts. And we can go to the next one. This one I think we can just go right past because we've been covering that quite a bit. I just don't want people to feel it's too repetitive. Gifts of securities we talked about include stocks, bonds, and mutual funds. And then we talked about donors pay no tax on the capital gain, provided the stock is in their name. And we'll go to the next one. Tax benefits. Again, this has been covered. Don't want to make everybody feel... but it's an interesting one. If you look at that last one, it should not be the primary motivator for giving, right? I think to me that says a lot, but it should be, the giving should be about, we want to do something for the future of the church or future of other charities. We can go to the next one. Oh, we're right into the foundation. Oh, this is good. See, I had taken some slides out because when I was listening to that wonderful presentation, I thought people are going to be going, I've just heard this. But I've worked for the diocese for the past 3 years. And the thing I found in my travels is that people don't even know the foundation exists, but they've been around since 1999. And our role is to raise funds and support the diocesan office, FaithWorks, outreach and education. And so since 2019, endowment within the foundation, we fully fund the operation of the Bishop of Toronto and will continue to do so in perpetuity. But the next slide shows some exciting things that are happening in the foundation if people are interested. We've started a new fund, which any parish can apply for. It's called For New and Emerging Ministries. So if you have a music ministry you're trying to restart, we have the Cowling Fund. But if you're trying to hire a family outreach worker, anyhow, I put it in there because you never know. There may be parishes that are wanting to restart some ministry, but that is one that we actually do quarterly. And we can move to the next slide. So here's one that is going to be sort of a little different than what's been will be talked about. We actually provide, and there's mixed feelings on this, and my colleagues, my fellow speakers may have mixed feelings on this, but we actually have an online tour that provides people can do their will for free online. And I'm going to pause there. So something that we've been doing, I've been doing these things called community wills clinics, and we've been doing them where dioceses are really working with people that are unhoused. So it's an opportunity for people to come in. It is a legal binding will. We do say if you have a complicated will, you need to go to a lawyer, but it can be printed out and they have 2 witnesses sign it. So for them, people very much living on the street, it can be for people, they want to know about their care, but it is something that's been around. We did check it all out. So it's secure and encrypted and all those lovely things we all have to deal with now, but that is available. It is on the website. So we'll just go to the next slide, and that may be the end. I think that might be the end. What have I got at the end? I think that's it. And then, this is about the online, because I think the thing, partially why we really wanted to start it, because again, obtaining a lawyer can be an expensive process. What I say to people is that even if you do the online tool and take that to a lawyer, it helps you start the conversation. Because as we were saying earlier, when I told the story about my brother who was 61, I mean, I should have sat down with him. But again, we all think, that we're here for good, right? I think that's the end. I think that is. Top 10 things. Let's do this one. Make a will, backing up the seminar you've already had, the seminar that's coming up. Make a will and authorize power of attorney. Inform family members of your intentions. Make a gift that supports the Anglican community. Leave a specific dollar amount, percentage, or share, and consider using assets to make a gift. And what have I got? I think I've got one more after that. Name the church. So there you go. That's right in there. As a beneficiary of an RSP, pension plan, or insurance policy, purchase a new whole life insurance policy and make your church the beneficiary. Leave a memorial gift to someone you love. Encourage others to leave a legacy gift. Contact a lawyer, financial planner, or accountant to better clarify the tax advantages, because always there are questions. There you go. And I think it's over to Alison.
No other questions for Mary Lynn? Oh, okay, Michael. Yes.
Just a little glitch in the Will 4, and I don't know if Mary can address that. We went online to try that Will 4.
Okay.
And we wanted to designate that grandchildren that would be beneficiaries would receive it after the age of 25. And there is a box to check for it, but it doesn't show up in the printed document. So it's a glitch in that system.
Interesting.
Okay. No, good to know. Good to know.
Okay.
I will talk to them about that to see if they, that there is some type of updating and can do it. No, good to know that. Thank you very much for that.
And I don't want to take any time away from or any comment from Alison, but I will say I think online wills are a fabulous tool. I think it's probably, considering what you're planning on doing, the magnitude of a mistake can be significant. It's worth the small amount. I think it's worth the small investment to run it by a lawyer just to make sure what you've put in there makes sense. Because I've seen nightmares that an online will company or service will never tell you about. So that's just my 2 cents.
No, and that's the opinion at the diocese too, right? Helen, you had a question?
Yes, Nora.
I was just thinking that online will might be a good first try.
Yes. Yeah, so an online will like Willfora would be a great way at no cost to start and begin, and that would be the backbone for what you might end up with eventually. Is that fair to say, Noah?
Yes.
Now that I've answered it for you, Marilyn, that's right.
Yeah, no, that's perfect. And that's really, it's meant to be, a start, a guide. I've got Helen's got her hand up. Helen, what can I answer for you today?
Just a quick statement. It's been my understanding when I was having to settle my father's estate with a lawyer that not to set specific amounts in your will, because you don't know at what your full asset complement will be until it's realized at, after your passing, and that it's better to put things into shares and perhaps state the number of shares and whether you want them equal shares or certain percentages.
That's great.
I've
Helen,
never
thanks for
heard it
that.
both
So,
ways. Oh, sorry. I didn't want to take in.
yeah, no, I'm just gonna say, for those who didn't hear or whatever, really the comment was, in a will, it's better to leave percentages or shares if you're going to split, rather than specific amounts. And if there are any further details on that question, I think Allison, when she does her presentation,
She can take it.
address them.
Perfect.
Okay?
All right. I'm going
Uh,
to excuse myself then, if there's nothing else. And everybody keep well today on a bit of a rainy day. And thank you for making me part of the community today. Enjoyed it. Thank you very much.
Actually,
Bye-bye.
Mary Lynn, I've got one quick
sorry.
thing. One of the things I learned many years ago when I was a warden is it's wonderful when people donate to the church and leave something as a legacy. What can sometimes be an issue is if the legacy has a specific request.
Yes.
It's for the organ. It's for it's for something specific that's near and dear to your heart, but that ties the warden's hands. They cannot spend that money on anything other than what that bequest specifies. So if you really feel passionate, great, do that. About, make sure that the money goes to that specific thing. But if you just want it to help the church, just say it's for the general operating or running of the church. That is so helpful. And because your will is your will, and the wardens have to respect that. And I'll say one last thing. There was a parishioner, I don't know if I can disclose, I won't disclose the name, but there was a parishioner who died a couple of years ago, maybe 3. And you would never have known, but she had significant assets and left all of that, or a huge amount, to the parish. And we're talking over $1 million. So the wonderful thing is that with a beautiful 150-year-old building, it's such an asset that we have. But it's also 5 times more expensive than repairing a new building. And to have someone leave that kind of money allows us to rebuild the steps. It allows us to do all kinds of things that otherwise we would be really struggling to do. So it's a wonderful thing. And she left it unencumbered.
Well, I'm going to start by thanking Tom and thanking all of you for coming out today. A little bit about me. So I'm an estates lawyer focusing on estate planning, estate administration. I've been doing it for just over 20 years now. And I like to tell people that, because they always sort of ask, like, well, how did you get into estates? Because it's, they don't make TV shows about it. It's not a particularly exciting area of law. And I like to tell people, I think I was probably brainwashed as a child. My father was an estates lawyer for 35 years. His uncle before him was an estates lawyer as well. So I have a long history of being an estates lawyer. But I think the one thing that impacted me the most growing up was my dad's motivation. We were talking about this before the seminar started. For him, being a lawyer was a tool. It was a way to help people. And he impressed that in me so deeply. Every time we would go anywhere, if we were going down to London to visit family, we had to stop along the way because there was a client he needed to see to get her signed up on her will. We needed to drop stuff off on the weekend to help a client out. We were always doing something, and it was just about helping people through what can be the most difficult and challenging time in their life. And so as I listened to the presentations this morning, I couldn't stop smiling, because I feel like we're all aligned in the message that we have for people and our approach to, how we do our work in this estate planning world. Coming here today and thinking about this is a huge step. Getting a will and powers of attorney and an overall estate plan in place is, I can tell you quite sincerely, the best gift that you can leave to your family and loved ones. Because if anybody has suffered a loss, and I'm sure everybody in this room has, the grief causes a fog. It feels like you're, disconnected from reality. You listen to things, but nothing seems to stick in your brain. And all the time, there's so many decisions to be made, so many choices to make, and you feel that pressure and you are just struggling to get through the day, to breathe in and out every day. And so having that plan in place is just a tremendous gift that you can give to your family, to know they thought about it. They had everything organized. I know where all of the information is. And a lot of this stuff has already actually been put in place. So I just need to call somebody and say, go, initiate, do that thing that you're going to do. And so, you know, again, like I said, I really applaud and commend all of you for being here. And I thank you for inviting us all to come and chat with you about this today. Okay, here we go. So my presentation is called Planning Ahead and Being Prepared, because that's the goal. So I usually start off with just a general, why should everybody engage in estate planning? And obviously the most common one is to ensure that your wishes will be carried out both in your lifetime in the event that you become incapacitated and ultimately on your death. Saving taxes and administration expenses seems to be a catalyst for a lot of people that I see, and I completely understand that. But as I said, the most compelling reason that I think everybody should do it is to assist your family in managing your affairs in your lifetime in the event that something happens, right? And they need to step in and support you, and ultimately to be able to administer your estate as efficiently as possible. So the basic will tools or estate planning tools are a will, a power of attorney for property, and a power of attorney for personal care. And so I want to just say to everybody that I work in this area, but I don't have any expectation that anybody that I deal with has any knowledge or understanding of any of the stuff in this area. We live in a time where you can Google everything and there's all kinds of information that floods over you. And I think that we sort of internalize this feeling of, I should be able to figure it out myself. I should be able to find the answer. But it can be really overwhelming and it can be very confusing. And the role of financial advisors and lawyers and accountants is not just to do what you tell them to do. It is to give you information and to communicate with you and make sure you understand what you're doing and why you're doing it. So I think that that's a really important, I think I went too far on the slides here, sorry, maybe not. So in terms of having a will, we kind of covered this a bit already. If you don't have a will, here in Ontario, there's legislation called the Succession Law Reform Act that will dictate how your will is distributed. If you have a married spouse, they are entitled to a certain percentage of your estate. They have what's called the preferential share, currently set at $300,000. If you have children, your spouse gets the first $300,000 plus 1/3 of the balance of the assets. The other 2/3 go to your children. If you don't have a spouse, it goes equally between your children. If any of those children have predeceased you, their share gets broken down between their kids, and so on down the line. If you don't have any what we call lineal descendants, people younger than you, it goes up to your parents if you have them. If you don't have parents, it goes to siblings and then down through the branches that way. What most people realize when I tell them that is that there is at least 1 or 2 branches on that tree that they would not like to benefit from their estate. And so in order to make sure that doesn't happen, you actually have to put a will in place. The other thing that you miss out on is getting to choose who's going to be in charge of administering your estate. So again, the Succession Law Reform Act has sort of a hierarchy of people who have the first rank of priority and down to be appointed. And obviously, if you have a spouse, that's great. They're the first person who has the right to apply. Interesting thing in Ontario these days, you can have a legally married spouse and a common law spouse at the same time. Oh. And there's no differentiation in the Succession Law Reform Act between who gets priority. Most people in a current common law relationship with a spouse still sitting out there somewhere probably don't have their spouse being the one who's in charge of administering their estate. Also, common law spouses, as opposed to married spouses, don't have any legal right to anything in your estate. So if you're living with somebody in a long-term relationship, but you're not legally married and you don't have a will, they are going to be left with nothing unless they make what's called a dependent support claim against your estate, which is just what it sounds like. It's a lawsuit against your estate. costing money, taking time, making life more challenging. You don't have any ability without making a will to leave specific gifts or bequests. So when we're talking about gifts, we have bequests. That's just a legal term for a gift of an actual object. You know, my engagement ring to my eldest daughter, the piano to my nephew, whatever. A legacy is what we call a gift of money. That's the only difference. There's legacies, bequests. If anybody who becomes entitled to share in your estate is under 18 years of age, without a will, there's no trust provision, there's no instructions that this person can hold that money until they're old enough legally to receive it. So instead, that money has to be paid into court. It sits with the accountant of the Superior Court of Justice until they're 18 years of age. They make an application, that money is released to them, they get 100% of that money at 18. Whether it's $5,000 or $5 million, you don't get to put any terms or conditions around it. So as you can probably guess, if you don't have a will, it will cost your estate more money to deal with the administration. There's just no two ways about it. It's absolutely going to cost your estate more money because fundamentally, without a will, somebody needs to apply to the court for probate, and that's going to cost money right off the bat, right? Then you've got all of these other uncertainties, tracking down beneficiaries, figuring out how to deal with everything. More time, more money. Okay, so we talked about this. What about will kits? And I have to say, you know, when I heard it come up in the first presentation, I kind of braced and I thought, oh gosh. And then in the second presentation, because of the online platform, but I have to say what they said is exactly in line with what I say. Most of these products are really well-made products, right? They're done really well. The risk comes in, this is no offense to anybody in this room, when you guys complete them, right? And the reason for that is really straightforward, because you aren't experts in this area. You don't know what you don't know. And if you do one of those and you just put it in the drawer, nobody gets to check your work until after you're gone, right? And after you're gone, you're not there to explain what you really meant or to say, no, I actually wanted to do this thing, or to catch a mistake. And so if you're thinking of doing that, I really like the idea of using it as a starting point to start thinking about what you want to do, start thinking about what your options are. And then whether you complete it all yourself or you then take it to meet with a lawyer, I do strongly encourage having somebody check your work for you, just to make sure that it works out the way that you want. Without going too far into the weeds, I can tell you that in the 20 plus years that I've been doing this, I have seen a number of, fill in the blank will kits, online documents. Every single one that's come into my office has required litigation. Every single one. Yeah. So I'll give you a couple of examples, and the lady who made the comment online previously about the dollar amounts, that was one of the first ones that I saw. And it wasn't dollar amounts. What it was this gentleman he named an executor, perfect. He had set out who he wanted to get his house, his car, this bank account, this investment account, this other asset. Can anybody think what the problem is when he died? You owe money when you die, even if it's a cell phone bill, property taxes, like there's always money that somehow has to get paid. And if you've designated all of your assets or you've calculated all of the dollars as gifts to people, what happens is legally, all of that has to be cashed in. It all has to be put in one big pool. They have to pay all the debts and liabilities, and then they have to track, okay, so that account was worth 1/4 of the total value of the estate. So 1/4 of the expenses will be deducted from each of those. And down we go. And then you have to account that all to the beneficiaries who then go, why am I not getting the thing I was told I was going to get? And they run off to lawyers and the lawyers start writing letters. And again, more money, more time, more aggravation. And of course, he thought he had done something perfect. I knew every asset I had. I owned all those assets when I died. Like, what could be the problem, right? So anyways, in general, have somebody check your work just to make sure that what you want to happen is actually what you said in the document. Handwritten wills are called holograph wills. They are still legally valid here in Ontario. It must be entirely in your own handwriting, signed and dated. If it is entirely in your own handwriting, signed and dated, it doesn't need witnesses. For will kits or anything where there's a pre-printed component of it, it will require 2 witnesses. They cannot be beneficiaries. They cannot be spouses or children of beneficiaries. That often makes it hard for people to find witnesses once they've kind of gone through that cycle. The other thing that happens with those documents is when you pass away, if, like we've talked about, there's a need for probate, then when the will is submitted to the court, they also need to submit a document called the affidavit of execution. And that's an affidavit sworn by at least one of the witnesses to your will. It has to be commissioned and it has to be attached to the will as an exhibit. And most people who do one of these documents didn't have an affidavit of execution done because they didn't involve a lawyer. So now the family needs to track down who these witnesses were. Hopefully you've kept a up-to-date contact information from them, track them down, go out and see them, get them to swear an affidavit of execution for you. Conservatively, 1 hour of lawyer's time is going to be roughly half the cost of your will to do it in the first place. So again, just things to keep in mind in terms of practically, are we saving money or are we just making it easier on ourselves and leaving more work for other people down the road?
Question?
Can we do questions at the end? Is that all right? Okay, thank you. So again, just because we've got a lot to cover and I'm going to move through this pretty quickly. Powers of attorney, we've talked about them a little bit, but again, just on the terminology side, because again, it can get confusing. Power of attorney for property are effective over your assets. So when we say property, we don't just mean like real estate, real property. We mean any financial assets that you own. The individual or individuals that you appoint to be your representatives are called your attorney, not to be confused with a lawyer. Here in Canada, lawyers are barristers and solicitors or lawyers. Attorney is a US term and unfortunately causes no end of confusion up here in Canada because in this context, it just means your legal representative, the person or people you have chosen. You can include conditions or restrictions in a power of attorney for property. But in those cases, what we usually recommend is that you have a general power of attorney for property, a document that says this person can do whatever needs to be done with respect to my financial assets, whether it's paying bills, filing my income tax returns. If I get into an accident and I'm in a coma, they can initiate a lawsuit on my behalf. They can deal with any of the things that might come up to deal with my assets. If you're doing a limited one, we sometimes see those for, it can be limited to an asset. I authorize my son to sell my condo because I'm going to go on a cruise for 6 months and I don't want to have to be here and sign paperwork. Or it can be limited to a bank account. I want to allow my general manager to be able to access the bank account to do with my business. But in general, everybody should have a general power of attorney for property. It's effective from the time that you sign it, not from incapacity. Okay, that's an important thing for people to remember because as you probably know, there's a big difference between I am fully capable, I'm doing everything myself, managing everything myself, and I am completely incapable, medically incapable of making decisions and managing my assets. And most people have a range of time in there where they would like some assistance. I would like my son to be able to get on the call with CRA so that I don't have to negotiate whatever that phone system is and deal with those people when I have to talk to them. None of it makes any sense, right? I want help during that period. So unless or until you want the help, you do not give them the power of attorney for property because as soon as they physically have it, they could theoretically go to your bank, access your bank accounts, take out lines of credit, change your investments, flip those assets. That's the power you're giving them. You're giving them that power because they need it, but you choose the people that you trust to exercise it on your behalf and in your best interest. While you're capable, you direct them to do something, they report back to you that they have done it, you track your bank accounts, you track your assets, you make sure they're doing what you told them to do, and if at any time you have any questions, concerns, or reservations that they can't answer, you can revoke your power of attorney for property, appoint somebody else, and get them to account for everything that they've done. They are legally required to be able to account for every penny in and every penny out of their administration. And if you pass away before they've accounted, then the beneficiaries of your estate have the legal right to get them to account to make sure that all the money that should be there when you die is in fact there at the time that you die. Power of attorney for personal care is just what it sounds like. It's the document that allows you to appoint one or more individuals, also called your attorney, to make healthcare decisions on your behalf. This one is limited to while you are incapable. So it's only effective if you become mentally incapable, and it's only effective for so long as you are mentally incapable. That's a concern that a lot of clients of mine have. What if I get ill, I go into the hospital, the kids start using the power of attorney for personal care? Do they just get to decide then forever? They can just put me in a home, they can just do whatever they want? If you regain capacity, you go in, you have treatment, you get your medication straightened out, whatever it is, and you're back in business, no, you regain the decision-making over your health care. So health care, nutrition, hygiene, shelter decisions. Also, the level of capacity to make your personal care decisions is actually lower than the capacity that you need to have to manage your finances. So that's the one thing, you get to hold on to that decision-making longer than people might otherwise think is appropriate, but you get to maintain your autonomy for as long as possible in that respect. You can include instructions or directions concerning healthcare decisions, end-of-life decisions, accommodation preferences. And then in the event that you're not able to communicate and express those wishes, your attorneys are bound by the wishes that you set out in the document. So I'm seeing these more and more. There was a time when I first started where I would have a discussion with clients and they would say, oh no, I don't want to put anything in there because you never know what medical science is going to come up with. Maybe they're going to come up with some amazing cure, and like, I don't want to rush things. I think what we've seen over the last 20 or so years is people are living a lot longer. But the question has now become not how long can I live, but what's the quality of that time? And so they often find that when they try to have conversations with their kids, they say, oh, I don't want to talk about it. Like, no, don't worry about it. Like, well, and so if you haven't had that conversation, it's really helpful for the family to have some guidance as to what you would or wouldn't want to do, because it can be really hard for them to make those decisions, right? For ourselves, we're pretty easy. We know what we want, what we don't want. We can be pretty strong about that. Even for our spouses, I think, you often have those conversations and feel pretty comfortable, but it's a little bit different when it's going to kids or grandkids. There's a different level of responsibility and almost guilt that goes along with some of the decisions that are made. So having some of that set out in your document can take a lot of that sort of guilt and responsibility off their shoulders and take away a lot of potential disagreements. Should we be doing this extra treatment? How long would they want to live like this? Those kinds of things. Again, always best to be able to have open conversations with them while you're healthy and well, while it's not emotionally charged. But if you haven't been able to, or you feel like I did, I'm not sure they were listening, I'm not sure they took it in, then you want to make sure that it goes in the document. But those discussions are really helpful also to help you decide, am I choosing the right people for these roles? Right? People will often think, oh, I'm going to appoint my eldest child to be the executor, right? They're the eldest, that's what they get. But they may or may not have the skill set for that role. Similarly, for personal care, people may say, well, I want all the kids to be involved. Well, do you? Do they ever agree on anything? Who actually shows up when you need something? Who actually makes time out of their day to come and take you to the doctor? You want to be practical about setting it up in a way that makes sense for you and your family, and it's going to be able to be used in the way that you want and need it to be. So, last topic that everybody wants to hear about as well is taxes, and we've touched on this a little bit, but just a bit of an overview. In the world of estates, we usually hear 3 different types of taxes talked about. Estate taxes, which are sometimes referred to as death taxes or succession duties. Income tax, we are all unfortunately very well aware of that one. And then this estate administration tax that's come up a few times so far this morning. So the good news, there are no death taxes or estate taxes in Canada, neither at the federal level nor at the provincial level. There is no tax that you pay simply because you died. Okay. That's the good news. Okay, there we go. Income taxes. Here we go. So we've touched on this briefly, but just as a general overview. When you pass away, your estate is taxed as if you had disposed of all of your assets in that final year of your life. So if there are any capital gains, they're triggered by your death. If there's any income that's been earned in that last year, whether from employment, pensions, or investments, all of that income again is accounted for and reported on your return. We've talked a little bit about the idea of spousal deferral on capital gains and rollovers on RRSPs and RIFs. Those are general concepts, again, unfortunately, only available if you have a spouse that has survived you. And it's not that the tax doesn't happen, it just gets pushed farther down the road, which, hey, we'll take it if we can, right? We've talked about this as well. Charitable bequests in your will, great opportunity to reduce taxes. You don't have the same limitations in terms of how much can be written off against your income in your estate. So in consultation with your financial advisor, you can come up with a plan that's going to potentially do, as was illustrated through some of the examples, a tremendous amount of good for an organization that you want to support, while also saving your estate tax. So it's a win-win in that situation. So estate administration tax is a provincial tax on assets that are subject to what used to be called probate. Now, everybody still uses the term probate because that's the word that we've used for hundreds of years, quite honestly. It's technically now called the, there we go. Sorry. Technically now called Certificate of Appointment of Estate Trustee, but for the purposes of this discussion, we can still call it probate. Currently, the way that it's charged is it's not charged on assets up to $50,000. So if you have an estate worth $50,000 or less, even if your estate needs to make an application to the court to get that probate document so that the bank or whoever will release assets to them, there's no fee for it. If you have assets that exceed $50,000, it's 1.5% of the value of those assets on the date of your death.
Is that over the $50,000?
Yes. Yeah. So if you have $100,000 worth of assets, you pay 1.5% on $50,000 of assets. All right. So yeah, like I said, it's technically now called the Certificate of Appointment of Estate Trustee with a will, if you have a will, or Certificate of Appointment of Estate Trustee without a will, if you don't have a will. It is, as we've discussed, required by financial institutions, banks, investment companies, brokers, all of those people before they're going to release the assets to your estate trustee. And as we discussed earlier, the reason for that is because basically we have a very litigious society these days, and they don't want to get sued by somebody else down the road saying, that wasn't a valid will, that wasn't the last will. The executor actually is a criminal who's been charged with fraud, so they were never supposed to be in charge of the money. They don't want any of that. So by getting the probate from the court verifies that the will meets all the legal requirements to be a valid will. Notice goes out to all of the beneficiaries of the will, providing them with a copy of it. And it provides time for somebody to object, to say, that's not the right will, or that was signed after mom was hospitalized. Like, she could not possibly have signed that document, or mom had been diagnosed with dementia for 5 years. She couldn't possibly have understood what was going on in that document, whatever the case may be. And if nobody objects, then the court issues the certificate of appointment, and then that goes out to all of the financial institutions and everybody else, and they go, great, thank you very much. We're happy to now release the assets to you, executor. It is also required, I think, as I mentioned earlier, in order to transfer or sell real estate in almost all situations these days. The Land Registry Office similarly does not want to get dragged into lawsuits, so they want certainty they're dealing with the right person. I will tell you that, again, from the conversations that you've had already about financial planning, and with help from a lawyer and a financial advisor, you can often avoid probate on the first spouse to pass. And if you're the surviving spouse, You may have to have probate, but there's a way to often reduce substantially the value of the assets that are subject to probate. Now, yeah, so that's the next question. So yeah, usually at this point in the presentation, everybody's thinking like, well, I don't want to pay probate. Like, how can I avoid that? But what I want to caution people about is doing things without some advice and direction. Because when probate changed and we got this new estate administration tax, a lot of well-meaning advisors, this was like 20 years ago, were telling people that through beneficiary designations and joint ownership, those assets pass outside of the will, so there's no probate on them. So then we had all kinds of people who ran out and put one or more of their children on everything that they owned. And now we've had 20 years of estate litigation over the things that were done. Because one, you can, by adding people to assets, trigger capital gains tax immediately, or create capital gains tax that you wouldn't otherwise have. So for example, if you own a home and you think, well, if I just put my kids on title to my home, then when I die, we don't have to pay probate on that. The thing that you've missed is that if your child also owns a principal residence, they can't get the principal residence exemption on their interest in your home. So while your home previously had no capital gains tax, now from the date that they go on it till the date that it's sold, any increase in value for their proportionate share is now taxable capital gain attributed to them. So one, you've created tax that didn't exist before. The other thing that happens, not only to homes, but bank accounts, investment accounts, is as soon as you put somebody else on title to that asset, they own it the same as you. And even if your child would never do anything improper, nobody's child ever does when they put them on, right? Those assets are now subject to their creditors. So if they get in an accident or they have some other situation and they're getting sued, your assets are now subject to those creditors. If they get separated or divorced from a spouse and there's a family law equalization plan going on, that asset is now subject to those claims. So now you've put your assets at risk. The other thing that can happen by doing that is you can inadvertently undermine the overall estate plan that you have. So an example of that is, oh, I have a house and I have a RIF. My daughter lives with me in the house, so I want her to just get the house and she'll stay there and my son will get the RIF. And I put him as a designated beneficiary. She's shaking her head. She knows exactly what I'm talking about, right? She talked about it. It's going to a child. That child gets the money. The estate pays the tax. Who pays the tax? The daughter pays the tax. That's not an equal distribution anymore. And that's aside from the potential change in value of the assets relative to each other, right? So in all cases, there are options and strategies to at least reduce, if not eliminate, the estate administration tax, but they should not be done without the consultation of professionals so that you can game out what would actually the impact of this be. Okay, so I made it to the end. Anyways, so all of that is to say we've covered a ton of material today, very high view. I was asked by Tom if he could send out my slides. After seeing them, I'm sure that you go, they're not really that helpful, and they're not, kind of on purpose because I'm a lawyer, and so I have to do my disclaimers that, like, you know, everything that I've said is just, you know, general advice, not specific advice or direction to any of you. But if any of you would like additional, more specific information about the role and responsibility of an estate trustee, or power of an attorney for property or personal care, or, you know, common law spouses' rights to an estate, anything like that, please take one of my cards and send me an email, and I'd be happy to send you some specific information on any of those particular topics. In addition to that, and we didn't have time to get into it today, but if you have beneficiaries who have special needs, who are either disabled on ODSP or under any other restrictions or limitations, there are additional levels of discussion that should be had about how you set up your estate plan in order to protect them and to provide them in terms of benefits that they might be receiving from the government, because those can be really restrictive. So again, lots of other topics that we could chat about. And if anybody ever wanted me to come out and talk again about a specific topic, I'd be more than happy to do that. But for today, I'm also happy to answer questions.
Question?
I don't know if Tom, you're gonna direct, but I was gonna say the lady at the back had her hand up before I even finished speaking.
Yes,
Where's the lady in the back? Okay, Debbie, yes.
lawyers also deal.
So estate planning lawyers can help you.
Sorry, the question was, does estate planning include medical assistance in dying?
And so to some extent we can, but the process is very regulated and is really more directed through your family physician or the physician who's treating you. Currently, the way that MAID stands, your attorney for personal care or any other individual is not able to consent to MAID on your behalf at this time. The legislation is evolving. It's going through changes. We're actually doing a presentation at the Hamilton Law Association next week. And we're having somebody come in from Dying with Dignity to talk about MAID to our estates lawyers so that we have a better understanding of exactly where things are right now, because it is an ever evolving thing. And so right now, lawyers don't really have an active role in it other than to talk to you about, again, powers of attorney, planning, making sure you've got things in place.
So it's just a family doctor.
That's usually the starting point.
At this point, yes, it's a family doctor. And if I could just interject here, Roshni and I talked about this whole series of what we would be talking about and what we would not be talking about. And MAID is one of those topics because it's still in flux. And if you think talking about writing a will gets you choked up, let's not talk about MAID, right? So it's too complex. It's outside the scope of what we're looking at here. So that'll be the last question on that. No, just as an attorney to shut you down, but I want to make sure that we're clear on what we're not going to talk about.
If it was included in your list of certs.
Yeah, sorry. That was heavy-handed. I apologize.
Okay, sure.
I want to go back to a question about a witness.
Yeah.
I'd like to understand the role or the responsibility of the witness. Is it there to witness your signature or to witness and understand the entire will?
That's a good question. So the question is for people online, if you didn't hear it, was what's the responsibility of the witness? And the witness's responsibility is limited to witnessing you put your signature on the document. They are not attesting to the contents of the will. They don't need to know the contents of the will. They're not attesting to your mental capacity even. They're literally just saying, yes, I was physically present and saw that individual sign.
Who determines capability?
That's an excellent question, and one for which you get a very lawyer answer, which is it depends. Yeah. So for a will, it is ultimately the drafting lawyer who is responsible for ensuring that their client has capacity, both at the time they give the instructions and at the time that they're ultimately signing the document. Because of the nature of capacity and the nature of our litigious civilization, often lawyers will then require a capacity assessment to give them comfort that the individual does meet the legal requirements. A capacity assessment is done by a licensed capacity assessor in Ontario. These are not doctors. They are often nurses or nurse practitioners or other individuals who've received special training to specifically determine capacity. That's similar for a power of attorney for property. It's less fraught often because of the fact that the power of attorney for property can be used while you're capable and into incapacity. So often it doesn't come up as much in that area, and it's kind of the same idea. Whoever's dealing with the individual may question whether or not they have capacity, may then say, do you have an attorney for property? And may put in hurdles there, again, wanting a capacity assessment. When it comes to healthcare, personal care decisions, it's, again, it depends. And it depends on what decision needs to be made. So often if it's, somebody's in the hospital, they are undergoing treatment for something, whoever the physicians are that are dealing with that individual will make an assessment as to whether or not they feel that person has capacity to be giving their instructions on that. If they are not in a hospital or under the specific treatment of a physician, the first request usually goes to a family physician, if they actually have a family physician these days. And again, if the family physician isn't comfortable making that assessment, the default is always a formal capacity assessment. Yeah. Yes, sir.
Okay. Mentioned several times about documents like a POA.
Yeah.
POA could be changed and so on.
Yep.
Let's assume a POA is changed.
Yep.
How is it sort of registered with the will?
There is no registration of wills or powers of attorney anywhere. So that sort of leads back to why I tell people you don't give out your power of attorney documents unless or until you actually need or want them to be used. Because once you've handed them over, if you decide I really don't want that person and I'm making a new one, even though the new document formally revokes the previous one, if it's still floating around out there, the world at large doesn't know that until somebody shows up with a newer one. So it's always best to hold on to your documents unless or until the people need to act. And in that case, once they're acting, often capacity becomes an issue and can't be
Some
changed.
century question. Let's assume we've done the right thing with union advertising. We've got a will.
Yeah.
What do we do with the will? How do we keep it?
Yeah, and so that's something that's kind of evolved over time. Historically, the question is, where should you keep your will? Historically, lawyers would hold what was called a will vault, and they would store everybody's wills. That made a lot of sense when people lived in the same towns or villages their whole lives and their children still lived there and nobody ever moved. It's become less practical these days. The Law Society requires lawyers to retain wills for 125 years after the person dies. So when my colleagues and I started our own law firm, I told them right off the bat, I will not be maintaining a will vault. I'm not willing to pay to store wills forever that may or may not still be valid because people have gone off and done new wills and updated them and I'm still holding old documents. A lot of people will say safety deposit box at the bank. I would remind you of not too long ago when we had COVID and we discovered that banks could just close and not have anybody available to open them or to get documents out of safety deposit boxes. We dealt with that a lot, particularly in the first few months of COVID. There's literally nobody who could get to the boxes. The other thing you need to remember is that, yes, if you've done everything right and you have your booklet and you have your safety deposit box key, in that booklet and they can get in there with, oh, wait, they need a will to show that they have the authority to get into the safety deposit box. All right? They need at least a copy of the will that shows that they're named as the executor to get authority to just look at the safety deposit box. So what I say to people in this day and age where computers are where we store all our documents, right? Once the will is signed, no, you're not keeping your will. What I'm saying is once the will is signed, if you have that booklet or you have a place at home where you keep all of your important financial records, income tax returns, all of the other important documents of your life, that's where the will and powers of attorney should be. In the same place, so that when somebody needs to do something, they go to one place and everything they need is in that one location. And what I say to my clients when they sign is, if at any time you cannot put your hands on your will, you do not know where it's gone to, if you spilled a cup of coffee on it, if you accidentally did a big spring clean and put it right through the shredder. I had a gentleman who was on the phone with me and I listened to it go through the shredder as he talked to me. You call up the lawyer and you say, I need to re-sign my will. And they pull it up on their computer, they redate it, you come in, you re-sign it. It was more important back in the day when we were handwriting wills out or we were typing them out on the typewriter even, right? That was a big undertaking to create a will. Now all the documents are stored electronically. It is absolutely easy to just print a new copy, re-sign it, and you're back in business. Yeah. So,
One thing about keeping them handy at home, they should be in fireproof something.
they should be in a fireproof something. But I mean, on the odds, again, if you've made it out a lot, you can re-sign your will, right? The other thing that I would say is, again, it's different from lawyer to lawyer, is that although I don't maintain a will vault, what I do retain is what's called a notarial copy of the will. So a photocopy that has all the signatures and everything on it. So it's a photocopy of the signed document with a lawyer's certificate on top of it saying, I swear this is a true copy of the original. And if the original cannot be located, that notarial copy can be submitted to the court with an affidavit that says, this was their last will, they didn't intend to revoke it, you know, it got lost in a fire or whatever happened, right? And the court will accept that document. So there are ways to sort of safeguard against those things. Because for me, it's always that balance of, let's make it practically as easy as it can be for them.
Questions from online. The last question is how to make change, or can you make changes to a will by hand and initial it?
Can you make changes to a will by hand and initial it? Yes, but you can't do it alone. If you change your will, you need 2 witnesses to initial and sign saying that they witnessed the changes to your will. And depending on what changes you make, the court may look at it and say, you haven't made changes to your will. You've destroyed your will. Because if you go through and you cross things out and you make notes on it and you say, actually, I want it to go to this person, that's not updating your will. That's destroying your will. So again, while it can be done, I strongly discourage people from doing that.
Second question, how is property taxed or not when leaving the home to a child?
So if it's a real estate, like an actual home, a physical home, if it was your principal residence, when you die, there's no tax, there's no income tax on it because it was your principal residence. And like any gift, your beneficiaries receive it tax-free. So here in Canada, beneficiaries do not pay tax on anything they receive, whether it's a home, cash, an investment account, nothing. They don't pay tax. Your estate pays the tax. Once it goes to them, it's tax-free. Only if they then invest it and it starts earning money for them do they have to report the income, etc. But no, beneficiaries don't pay any tax in Canada. If you have beneficiaries that are in the US or the UK or other jurisdictions, there is an inheritance tax. So in those jurisdictions, they may receive money and then have to report and pay tax on it. So I do strongly encourage people, if you have beneficiaries that are outside of Canada, to look into those issues to see what implications there might be for that. Yes, sir.
There being more than one executor, and how do we compensate them?
Yeah, so you can have as many executors as you'd like. If you're having more than one, I strongly encourage you to make sure that there's some provision in the will that speaks to how disagreements are going to be resolved between them, because you never know. You certainly want to appoint people who are going to work well together. Again, I don't recommend appointing all the kids just because you're trying to be fair. I don't know if anybody here has had the honor of being an executor before. Yeah? Would you ever want to do it again? No. Right. Nobody who I've ever met is offended if they're not asked to be an executor a second time. So what I would say is you pick the right people, make sure they work together. In terms of compensation, anybody who acts as an executor is entitled to claim compensation from the estate. Executors' compensation historically was calculated at the rate of 2.5% of any funds they collected, plus 2.5% of any funds that they paid out. Now, that was subject, and people say, oh, it's 5%. Well, roughly, because they're not allowed to charge compensation on any amounts that they pay to themselves. So if they pay money out of pocket on behalf of the estate and then reimburse themselves, they're not allowed to get compensation on that. Otherwise, we incentivize executors to pay everything out of pocket, then get reimbursed from the estate and get compensation on top of that. They're also not allowed to charge compensation if they're a beneficiary on the amount that they receive as a beneficiary. So that's why it's that rough 2.5% of receipts plus 2.5% of disbursements. That is subject to review by the beneficiaries, as well as if the beneficiaries don't like what the compensation amount is, by a court ultimately. And it needs to be judged against what the actual size of the estate was, the care and responsibility involved, the time that it took, and the results that are achieved. So if you have, for for example. And I've seen this before, you know, an elderly person who's in a care facility, when they pass away, they had an investment portfolio that was funding a bank account that did automatic payments for all of their care costs, right? If that's worth $10 million for closing out those two accounts and paying the money out, you don't get 5%, right? But we have other situations where we've had people who, you know, they owned multiple properties, they were all mortgaged, there were leases, there was all kinds of stuff going on. At the end of the day, the value of the estate wasn't that much, but the work involved was substantial. And so in those cases, they are entitled to get increased compensation. So it's really dependent on the work that's involved, but they're entitled to get compensation. The bottom line. The thing that people need to know about compensation is that it's considered employment income. It is taxable. So, yeah. So, yeah, exactly. So if you are also a beneficiary, you're executor and beneficiary, it often doesn't make sense for you to charge compensation because half of like it's coming out of your own pocket and you're paying tax on it. And what I will say in that situation is, for example, if you had 3 children who were all going to share equally in your estate and you were going to appoint one as the executor and they do good work and everybody's happy with the work that they are done, instead of charging executors compensation, the beneficiaries can determine what they think is an appropriate distribution of the residue. They can say, instead of you getting 1/3, let's give you an extra $5,000 because you did all that work. We're just going to give the instructions that we're dividing the numbers differently. And if they all agree, the beneficiaries can do that. They can make sure that the person gets compensated without claiming executor's compensation.
Or you could leave some money in your will for the executive.
No, because that's what people started doing to avoid paying income tax. And the courts went, no. If you're a beneficiary and you get a legacy, that gift of money in the will, and you're the executor, we're going to deem that to be executor's compensation.
If one actually loves one's family and friends,
Nice place to start, yeah.
what sort of professionals are suitable for appointing as executors? Like, I've heard negative things about banks, lawyers, whatever.
So if you don't want to burden your family with being an executor, who would be an appropriate person to choose? You know, there are trust companies that offer executor services. All the banks offer executor services. Some lawyers will offer executor services. What I will tell you is that, like, I mean, I've already been appointed in family and friends all over the place because, you know, you can't say no when you're an estate's lawyer, but I say no to my clients. And I say no to my clients because, to be perfectly honest, you don't need a professional to act in that role. If you have organized your affairs and have everything in order, and you have spoken with your kids, connected them with your lawyer and your investment advisor and your accountant, all they need to do is sit with those people, listen to the advice and direction that they have, and say, yes, please go do that. Yes, please go do that. Yes, please go do that. And then they'll come back with papers and they'll just sign papers. And it doesn't have to be a terrible experience, but it's really how you guys handle things beforehand that will largely determine how stressful and how much is involved in that. So, you know, like I have clients who come in and they have their binders, right? They left this binder, it's got all the information, and they say, I just need some copies of the will and the death certificate, and I've already talked to the bank, and we've already done this, and we just need you to do these pieces. Great, no problem, happy to help. I have other people who show up at my office with literally garbage bags full of documents, and they go, I don't even know where to start. And we go, no problem. And we'll go through all of the papers and we'll figure out, you know, oh, these are old life insurance policies that are old and old and old, and this one's been converted to this and this, and we'll track it all down and we'll figure out what needs to be done and we'll guide them through it. I hear horror stories all the time, and it makes me so angry, to be perfectly honest with you, of people who are dealing with lawyers who aren't helpful. They say, I don't understand what's going on. They say it's taking forever. I don't know why. And if you're feeling like that, you shouldn't be feeling like that. That is not the right professional for you. And so, you know, I always say to my clients, I'm happy to be there for your family if they want help and guidance through the process, but it has to be a fit. They have to feel comfortable working with me, and frankly, I have to feel comfortable working with them. And so it's really about the fit with professionals. And so if you can make any of those links and connections now, it really helps to smooth over that period. I will tell you from my own experience, my father passed very suddenly, almost 1 year ago. You know, he was an estates lawyer, so, you know, he had some stuff done. And so my mother, who had always sort of deferred to, I mean, she paid all the bills, she managed the house, like she was not, you know, financially literate, but she'd never met with a financial advisor. She'd never dealt with investments. She was so overwhelmed. So she said, Alison, can you go with me for my first meeting? And the advisor was fantastic. He had all the paperwork. He had a little PowerPoint where he took her through and said, these are the things that you have, and these are the decisions that we've made over the years, and this is how it's going to work, and this is why it's going to work. And she felt calm and empowered by that situation. I will say that aside from the financial advisors and the lawyers, I would strongly encourage you to meet with a funeral director. You do not need to prepay for your funeral, but you should sit down and talk to them, let them gather your information, have those discussions with them, because to be perfectly honest, lawyers, financial advisors, accountants, there's no rush, right? You can deal with us when you've had some time to acclimate, when things have settled down a little bit, but the family needs to deal with those final decisions immediately. There's urgency to those decisions, and those are the decisions that can be super overwhelming and collecting paperwork and things like that. And that's the one thing my dad didn't do. And he used to do these seminars where he would talk about reclining funerals. And that was really hard. So even for me, who does this every day, I wasn't expecting, you know, my dad went into the hospital on a Thursday and he died on a Sunday. And up until then, like literally the day he went into the hospital, he was doing a Zoom meeting with Conservation Halton. Like he had no expectation that this was the end for him. And so for us to then be having to have those conversations and make those decisions was really, really hard. And so I would just, that's my plug for, I don't get a commission or anything, but for sincerely consider doing that, because that is one really simple thing that's going to set the tone for how your family experiences that time after they first lost you. So I don't know if there's any other questions.
What do you think about putting money or property into a trust?
There are definitely pros and cons to it. About putting money or assets into a trust. So there's different kinds of trusts that are available depending on where you are in life. Things called an alter ego trust, which is for individuals over 65 years of age, joint partner trust between you and a spouse or partner. And then there are more traditional trusts, which are usually established because we'd like to leave money to somebody, but we're a little concerned about what they might do if they got it all out right. Some of those can be done and set up now and funded now. Some can be done through your will. Whether or not it makes sense is something that's sort of a more fulsome discussion based on your assets and the goals that you have for setting up that trust. The thing that you need to know is that there's a lot of tax implications to setting up a trust. So there's the cost associated with it, there's the cost of administering it every year from the time that it's set up, both in terms of just somebody who's managing it, the trustee, as well as the fact that once a trust exists every year, it's a legal entity and it has to file a tax return. So you have another tax return to do. So there's discussions that need to be had around what you're looking to accomplish and why you're looking to set it up. Yeah.
I'm just going to.
So many.
So what I was going to say is we don't want this to go on too long because we said from 10 to 12, we want to respect people's time. And we said from 10 to 12, then a light lunch will be served. So if we could have one more question, but then can you hang around for a little bit?
I can hang around for a little bit, and I will say I did leave cards here. And so if people want to email me, I'm happy to take questions. If it's a more fulsome discussion, I do consultations where it's like a 1 hour and we sit down, and whether it's reviewing a will, talking about your estate plan and deciding whether or not you need to change anything, we can do all of those now.
Okay, I'll hold back on my question, but I just want to say you're fabulous. We're not very
For the people online, that was a vote of confidence for Allison. So, you didn't have it, well, you,
I do have 2 minutes. So,
Yeah.
one thing I did want to say, I co-chair the Anglican Church Women's Group, and I'm thinking this would be wonderful to have you come and speak to our ladies.
I would be more than happy to. I'm a member of St. Matthew's on the Plains out in Burlington, and I've spoken to them, and I'd be happy to speak to any other groups that you might want.
Great.
My
Okay.
pleasure.
So just if I could make a couple of comments here. So first of all, thank you so much, Allison. That was great. I guess you probably do a lot of presentations where first people go, "Oh, I asked a lawyer," and by the time the end of your presentation, we can't pull you off stage because there's too many questions. So, and it's the same with the financial questions. Thank you so much for the presentation. One of the things I think for me is a takeaway. Get your will done. Put it in a safe place, but give your kids or whoever you want to help you after you're gone, get them a copy. There's no danger there. Also get your POAs put in place, but don't necessarily give them out. That's a mistake I didn't know until today. Mary Ellen and I planned, and we got, after 6 years ago, when Turner Reporter came to the men's dinner and did a presentation, I went home and I said to Mary Ellen, we've got to do what our parents did for us. We've got to get the planning done. So we did, we updated the wills, got the POAs and whatever, and then gave our kids a copy of everything and said, so there's no surprise. You all know how it's going to get divvied up when it's, you know what you need to do. I didn't realize that there's a downside of giving the POAs out ahead of time. So that's good. So keep it in a safe place, do the work, keep it in the safe place. Make sure you get the POAs done, hold them back, don't distribute them around. But I got one other thing I want to reinforce, if I can, the point of not having more, unless you absolutely have to, don't have more than one power of attorney, don't have more than one executor. My parents, luckily, it's funny, 3 boys, I'm one of 3 boys. We didn't get along very well throughout our entire lives, but for whatever reason, God's got a sense of humor. We worked together at the end with my parents. But they put us, all 3 of us, as executors, all 3 of us as POAs, and that is so dangerous. Luckily, we worked well together, but I don't know what your recommendation is, and I would say have one and make sure you have a mechanism that they communicate, and then there's some agreement. And if it could, I'll just tell you one last humorous but painful story. When my parents were aging, they were lucky enough to be able to afford to age at home, which they did. At one point, my dad had a stroke. You're going to edit all this stuff out anyway. He had a stroke and had probably 30% of the capacity that he did prior to the stroke. So we had a family meeting because my mom didn't know what to do and how do we deal with all these things. And there's a thing, by the way, it used to be called a DNR, right? Do not resuscitate. I think now the new terminology is AND, which is allow natural death. And so we needed to have that conversation with my mom. What happens with that? As we get towards the end, he's not in a position to make those decisions. What do you want for him? So we had the 3 boys, we had the priest, and we had the family doctor. It was a great meeting. And so we started, what do you want done? And then she said, well, what's involved? And the doctor said, well, unless a person is 30, 35 years old tops in fabulous health, when you put the paddles on them to try and get them back to life, it's not like on TV. It almost never happens. They won't. So the doctor's explaining how this happens, that they're probably not going to live. Oh, okay. But if they do, said Mom, what happens? Well, then they're probably not going to be mentally there. There's going to be damage. So probably they're not going to come back the way they would want to come back. Oh, okay. Well, yeah, I don't want that. So she's thinking for her husband, what do we want? And so this, well, how about if he comes back and he's mentally incapacitated? Well, I don't want that. So what do we do then? Well, the only thing to do then is to humanely hold back water and food with a lot of painkillers and just allow them to go. It's a dark subject, but I'm just saying these are the things you need to think about. And someone went, yeah, okay. And then the doctor said, but it won't be painful for him. He'll be well sedated. He's fine. It's going to be painful for the family to watch this happen because it could be 2 hours. It could be 2 months. You don't know. That is something she said, oh no, I definitely don't want that. Okay. So, right. Well, I'll put a DNR on his. I said, okay, now Mom, while we're on the topic, what do you want? She said, I want everything. Okay, so should we rewind that story about you won't come back or you'll be brain dead? Yeah, I want everything. Okay, so the point, I know it's kind of funny, but it's also like, thanks, Mom. What do we do now? The point is, especially when it comes to the POA for personal care or health care, whatever, as Allison said, have those conversations with your kids. What do you want? If this, then that. If that, and write it down because they need that guidance. We're doing all of this planning to help our kids or whoever know what to do when we can't make those decisions. Write it down, give them the help, give them the guidance. Anyway, I'll stop talking. Yes.
Even when you have that conversation and you know what, for example, in my case, I was the medical POA. I knew exactly what my mother wanted. It was the hardest thing I ever did.
Yeah.
So just to know that it was very, very, and you always second guess yourself.
And the other thing we did with our kids, one is the POA for personal care and one is the POA for assets. Just because we looked at their skill set and said, which of the two is better suited for this, which is of the two of our two kids is suited for that. So give that some thought as well. Hillary, did you?
Yeah, I just wanted to ask Allison, how often since you did say you've done this like 10 years ago, how often do you need to review it?
So the question is, how often should a will be reviewed?
So I like the suggestion that we had that, every couple of years. Years fly by, right? We often don't really remember how many years it's been. So what I usually say that sticks with people is births, deaths, marriages, divorces. Pull it out, read your will. Is everybody in there that should be in there? Is there anybody in there that shouldn't be in there? If you're not doing it every few years with your financial advisor or your accountant as part of sort of an overall review, major life events like that, births, deaths, marriages, divorces, that should trigger to you to pull out the documents. Because more often than not, people sort of, I'm not going to say misremember, but their memory of what's in there kind of morphs over time. And people are often really shocked when they pull it out that like, oh, I didn't remember that we'd done that. And why the heck did we have that in there at that time? So yeah, that would be my general guidance.
Yeah.
Great, thank you. If there's any other specific questions sorry, Jenny.
Just wanted to mention, because I didn't know whether it's going to come up with Allison's talk, but when we were talking about if you didn't have a human to be, or didn't want to name a human as your executor or even power of attorney for finances, there are trust companies, as you mentioned, and Raymond James, the company my investment firm, has a full service corporate executor company called Solus Trust. We're the only independent financial firm in Canada, that is to say, not a bank-owned firm that has its own trust company. So I have had a number of clients who, they're single, they don't have children, or their children are just for whatever reason not going to be the right people to name for that purpose. So a company like Solus Trust, which will charge, of course, a fee to do all of the things we've talked about. But again, they can't charge any more than what an individual Depending on the complexity
Yeah.
of what has to be
I
done.
was gonna say, usually they have like a compensation agreement.
Yes,
That you'll know when you're signing up.
That's
like,
right.
How they've charged their.
That's right, and that's something that we would ensure if they want to engage Solus Trust, then Solus Trust would have documents like the fees and so forth that would be, and the wording that would be given to their lawyer. We don't do the
draft.
wills, we don't do the wills. They would provide that to your lawyer, who would then make sure that all that information is in place. And you sign off on the compensation and everything else. So it's just another thing to think about if you really don't feel like your obvious family members are really the right people to handle that for one reason or another.
Thanks for that, Jenny. And again, I guess the other part I was gonna say is for my own learning out of all of this is being an executor is a piece of cake. If the person for whom you're being an executor has all the paperwork done, if it's all neat and tidy, well thought out, professionally advised, then it should be a walk in the park. Yes, there will be delays because the process involves multiple people. But if you do your stuff, put stuff in place, it'll be easy and you won't be burdening per se, the executive. All right. I guess I wanted to thank you, all three, for being, and thank you very much for a really engaged, very good session. These are complex conversations, but as I said back in the very beginning, one of my first slides, what was the impetus for this? It was to try and make sure that we're on the right path, or we actually get moving on the path, or we're just going, hey, I don't know, that's great, that's wonderful. Thank you for all of this. And I guess just a bit of an ad for the next one, which is in 2 weeks' time. I'm calling it residential because I couldn't think of a good name for that, but it's downsizing. And do you downsize your house? Do you downsize your life? Do you downsize? So how do you do that? How do you declutter if that's an issue? It almost guaranteed is. Is that yeah. So, and then what are the pros and cons of aging at home? What resources are available to you? Where can you get those resources? How much do they cost? Private versus publicly funded? A lot of those things are things that people also ask about.